Good afternoon. My name is Peter Grant-Hutchison. Thank you for joining me for lunch. I would say it is my treat, except I've seen some of the names on the attendee list, and if I say that, I'm sure one or two of them will send me the bill. The title of today's talk was Employment Law at a Post-Brexit and Post-COVID. And that is still going to be the unifying theme. But in previous years, we've managed to find a little humour, very dark humour perhaps, very black, sometimes quite bitter humour, and what's been happening with employment law. Last year we talked about transfer of undertakings. Time before that, we even found some humour in the concept of mass redundancies, although that was tinged with pain. The real topic today is employment law at a time of economic crisis. The talk will be in two halves, or if you're a fan of Liz Truss economics, three halves. The first half is a story, basically. It's a story derived from an employment tribunal that I've been doing quite recently. The names will not be disclosed and some of the facts will be changed. It's a strange story because there are no villains in it, and I say that because with employment law in particular, employment law can be quite political, not in the sense of party politics, but it's an area of law where people have a particular view, a worldview, or a moral stance about what is occurring. And it's quite easy to caricature some employers as rapacious villains with wax moustaches, and some ex-employees as being obdurate, unhelpful, depending on your perspective. But in this case, there are no villains, but there are possibly some heroes. The claimant. There's a major protagonist. The claimant worked in a caring area of society. Could be nursing, could be social care, but one of the caring professions. A claim was submitted to an employment tribunal, and that claim said that the claimant had been expected to work excessive hours. The hours were so excessive that she became ill with it. Now that seems like a good start to an employment tribunal. That's something that you think a claimant may be successful. Let's muddy the waters just a little. The claimant worked for a non-profit organisation. That makes it a bit harder to characterise an employer as a villain. But we do know, of course, that non-profit organisations can be exploitative, perhaps because they have to be. It is their economic necessity. So let's pause for a moment to look at the concepts that are involved, because it will be the legal concepts that might guide us to the end of the story, to see whether or not the claimant is successful in her claim. Well, the claimant's claiming unfair dismissal. Section 98 of the Employment Rights Act 1996 tells us that the first thing an employer has to do is to show a potentially fair reason for dismissal. We all know what these are: conduct, capability, redundancy. Sometimes there's a legal barrier to the person carrying on discharging the duties. And of course that great catch-all, some other substantial reason. That's often used in terms of a reorganisation of a business. But let's turn to another concept. Thinking of the facts of this case, the claimant says that she was overworked, putting in way too many hours. The claimant wasn't dismissed, she resigned. So that leads us to the next concept that we have to consider. Because what the claimant is now saying is that it's unfair constructive dismissal. We have to look at Section 95 of the Employment Rights Act 1996 for the definition of what is a dismissal. And the one that we are considering at the moment is Section 95C, which says, a dismissal is when the employee terminates the contract under which he is employed, with or without notice, in circumstances in which he is entitled to terminate it without notice by reason of the employer's conduct. All right, let's pause there. What sort of employer's conduct would give an employee the right to say, that's it, I've had enough, I'm walking off? Well, historically, we had a number of cases about a safe place of work. There were a lot of cases involving smoking in the days when you could do that. Sometimes there were cases about the system of work. Famous case of a hairdresser saying, I needed an assistant to work. I didn't have an assistant, therefore I can resign because it's unfair that you expect this of me. But by far the largest single reason that is advanced for an employee to say, that's it, I'm resigning, I've had enough, is what is known as a breach of the implied term of trust and confidence between an employee and an employer, which is necessary for the contract of employment to function. As a breach of the implied term of trust and confidence. Let's look at that a little further. In Western Excavating, a very well-known and historic case, Western Excavating ECC Limited v Sharp, 1978 ICR, page 1221, Lord Denning said the following: but the conduct must in either case be sufficiently serious to entitle him to leave at once. Moreover, he must make up his mind soon after the conduct of which he complains. For if he continues for any length of time without leaving, he will lose his right to treat himself as discharged. He will be regarded as having elected to affirm the contract. Now let's go back to our story. The claimant had, over a period of time, worked excessive hours to such a good degree that she became ill. Has she affirmed the contract? Is she no longer able to say that I can resign because you, the employer, have breached the contract? Well, no. Thankfully for the claimant, the law moved on and there were further developments. Over a fair period of time, a doctrine developed that a breach of a contract of employment by an employer could happen in a series of incidents. They had to have some connection, and each of them had to do something to damage that condition, that implied condition of trust and confidence. A lot of time, judicial time, was spent examining what became known as the last straw doctrine and what was said to be the last straw in any individual case. What did it have to be a breach of contract of itself? Well, the lead case in this, and still is to this day, is the London Borough of Waltham Forest v Omalaju, 2005, Industrial Relations Law Reports at page 35. Court of Appeal case. In that case, it was said, moreover, an entirely innocuous act on the part of the employer cannot be a final straw. Even if the employee genuinely but mistakenly interprets the act as hurtful and destructive of his trust and confidence in his employer. The test of whether the employer's trust and confidence has been undermined is objective. It is true that I rejected the submissions that it is a prerequisite of a final straw that the act should be unreasonable, if not of itself a breach of contract. The essential requirement is that it should contribute to a breach of the implied term of trust and confidence, but it will be an unusual case where conduct which is perfectly reasonable and justifiable satisfies the final straw test. So, the claimant in our story is having to show that there was an unfair constructive dismissal. She has to show that there has been this breach of trust and confidence, and the onus is on her. That's one of the reasons why unfair constructive dismissal cases is normally quite difficult for a claimant. But in the facts and circumstances of this case, she may well be able to do it. She'd have to show what is that final act. It might be quite difficult to show that. But we must, since the vast majority of unfair constructive dismissal cases are unsuccessful, I think it's appropriate to ask what constitutes a fair constructive dismissal case. In this context, I would commend to you the case of Glenhour v. Ealing Hammersmith and Hounslow Area Authority. Glenhour, Ealing Hammersmith and Hounslow Area Authority, 1980 Industrial Relations Law Reports at page 297. Now, what happened in this case? Mr. Glenhour was appointed to be the head of a procurement division for the Health Authority. It was a trifle unfortunate because just before his appointment, there had been a successful prosecution of his predecessor in that authority. We can guess what that was, given the job was procurement. The authority, perhaps understandably, said that no one should have that particular job of procurement for any significant period of time. So they went to Mr. Glenhour and said, "You're doing a fine job, but we want you to do a different job in a different place." Mr. Glenhour said, no. My skills would be wasted doing the job that you wish me to do, and I'm not going to work in that different place. So what occurred was that he resigned and he claimed it was unfair constructive dismissal. The Employment Tribunal and the Employment Appeal Tribunal said, "Well, you're partially right, sir. That is undoubtedly a substantial change in your contract of employment. You're entitled to walk away because that's breaching your trust and confidence in your employer. You're entitled to walk away. But it is also a dismissal for some other substantial reason. It's a business organisation. They're not trying to harm, or business reorganisation, they're not trying to harm your career prospects. In fact, the contrary, they said your career prospects would be better. So what has occurred is not an unfair constructive dismissal, it is a fair constructive dismissal. So, applying these concepts to our story, the claimant in the story, is the dismissal fair or unfair? Well, let's add one or two other factors to the mix. Let's say that the claimant is doing such an important job that if it is not done, the people, the individual client or patient, could be at risk of death or serious harm. That's what might occur if the claimant does not put in the extra hours. Let's throw another factor into the mix. Let's say the claimant is in junior management, and that claimant has got some responsibility for recruitment. But there is a crisis in recruitment. Remember the sector that she's working in. Does that change matters? Does that make her situation a fair, constructive dismissal? Let's add another factor into the mix. Remember, this is a non-profit organisation. Certain members of senior management believe the situation is so serious that they, and perhaps they're not terribly well qualified for it, undertake to work much extra hours, many extra hours, for the benefit of the people receiving the care, the patient, or whoever. When you look at all of that together, is that a fair or unfair constructive dismissal? It's certainly a question that we're going to be asked again and again and again when we have an economy and a care sector in crisis. If we've got time, we will come back to that. But I want to move on to the second part of our talk. And that's what happened on the 22nd of September 2022. 22nd September 2022 is going to be a fateful day. On that date, the retained EU law, Revocation and Reform Bill 2022 to 2023 was introduced to Parliament. It was certified as being compliant with the European Convention on Human Rights by that well-known defender of human rights and moderniser of employment law, the Business Secretary, Mr. Jacob Rees-Mogg. No doubt he introduced the bill because he thought it would facilitate future trade agreements with our well-known trading partners such as Cathay and Persia. What does the bill seek to do? It provides that EU-derived subordinate legislation and retained direct EU legislation will expire on the 31st December 2023 unless expressly preserved by ministerial order. This is referred to in the bill as being the sunset provisions. We can see why, because if nothing is actively done, the sun will set on these provisions and they will no longer be part of the law. The bill is designed to reform over 2,400 pieces of European legislation. Shall we consider the main pieces of legislation that will be affected, or may be affected. The Working Time Regulations 2010. My personal favourite, the Transfer of Undertakings Protection of Employment Regulations 2006. Fixed-term Employees Prevention of Less Favourable Treatment Regulations 2002. Agency Worker Regulations 2010. And Part-Time Workers Prevention of Less Favourable Treatment Regulations 2000. Let's pause at that last one for a moment. If any of the attendees are part-time Social Security judges, part-time immigration judges, part-time sheriffs, or indeed aspire to hold any of these part-time posts, they may well be disadvantaged in the future, because it is that set of regulations that guarantee similarity of terms, arguably the same, but we'll just say similarity of terms, with the full-time holders of these positions. It is those regulations which guarantee the part-time sheriffs, part-time immigration judges, their pension rights. So even if you don't hold these posts at the moment, if you've got any friends that do, warn them now. It also may be the case that if this type of European legislation is revoked, it's not maintained by a ministerial order, that some equal pay matters will effectively be repealed. I must say not many, because equal pay legislation was inherently UK and not European, but it may still be affected. And the duties to consult employees on mass redundancies may well be affected. It also does one or two other strange things. The bill gives the power to the higher courts and tribunals to depart from precedent that was created by or gave acknowledgement to European legislation. And to that degree, it quite radically changes the power of the judiciary. And it gives guidance as when the judiciary can use that power. And one bit of the guidance, and one has to listen to this, and this is guidance for departing from a precedent. You can do it if the precedent restricted the proper development of domestic law. Now that's requiring our judiciary to look backwards and see what the European legislation changed in domestic law, and to guess how domestic law might have progressed otherwise. That smacks a little of introducing archery practice by law every Saturday so we can fight the French. It's an impossible task and could border on the ridiculous when people try to undertake an impossible task. What ultimately is going to be the result of this act? Some academics speculate and seek comfort in the reassurances that Theresa May gave when she was Prime Minister. She says that after Brexit, employment law rights will actually be enhanced. Some take comfort for Boris Johnson's assurances that after Brexit, employment law rights will not be affected. Some more realistic academics say, well, the government is going to be constrained in what it is allowed to do by the UK-EU Trade and Competition Agreement. That agreement provides for an equal playing field in terms of employment law rights. I'm not so certain. Part of the argument about leaving Europe was that Britain could be more unregulated and could compete on the basis of a more flexible workforce. If that is the ethos which resulted in us leaving Europe, then one has to look at what the government may do with employment rights. I think what might limit what the government wishes to do will be two things. Firstly, the depth of the economic crisis that we face a year from now. I may say there is some provision that they can actually get round the sunset clause and continue some of the bits of legislation to the year 2026. January, I think, 2026. But by and large, the sunset clauses will be there, and they'll be constrained by the depth of the economic crisis, and also perhaps by the imminence of a general election. With these two factors, things might not be as drastic as they first seem. But I am just a little dismayed. When I came to look at the House of Commons Library research briefing on the effects of this bill, the research briefing was issued on the 17th of October 2022. It is 6 pages long. One page is filled with an email address, a set of email addresses, and one page has 2 sentences in it. The research tells us very little about what will occur, and the truth of the matter is we don't know what will occur. We can say that there's nothing that's going to occur which would help our protagonists in the story, which was the first half of this talk. I hope I haven't depressed you all too much, and I hope you will accept my invite to join me for lunch in a year from now, when we'll have a much, much better idea of what legislation still exists and what legislation doesn't. And my final words are going to be thank you for attending and thank you for listening. I see the numbers. Almost everyone that was here at the beginning is now here at the end. That was very gratifying. And can I also commend to you, this time next week, we'll have an even better lunch, and your speaker will be Kenneth Young on cross-border jurisdiction post-Brexit. Thank you very much.